Um, Welcome, everyone. While people are logging on and getting comfortable, I'll just run over a few housekeeping bits before we properly start. You can access closed captions by clicking the C button at the bottom of your screen. You can also access subtitles via streamer text, and my colleague Hannah will pop in the chat the link to that if you'd like to use that service. We will be tweeting from our Twitter account at Ada Lovelace Inst, and feel free to also follow the conversation there. We are recording this event, but as attendees, your videos won't be visible, and we'll be posting the recording on our website in the next few days. We're also going to publish a short write-up of the event as an aid for people who are thinking of their own consultation response and might want to turn back to some of the comments, and we'll publish those shortly. So now for a proper start, my name is Valentina Pavel, and I'm a legal researcher at the Ada Lovelace Institute. We are a research institute based in London with the remit to ensure that data and AI work for people and society. I'm delighted to have you all joining, and many thanks to our wonderful panelists for accepting our invitation. I will spend a few minutes introducing why we're here, and I will hand it over to our speakers to give their brief thoughts, then have some conversations and open up the discussion for your views and questions from the audience. So feel free to use the chat and put your questions in the Q&A box, and I will keep an eye out for them. This is the third event of a series that we have designed to engage with the data consultation that the UK has put out, and to also scrutinize some of the plans around creating a bold new data regime with a pro-growth and pro-innovation focus that positions the UK as a global leader in science and AI research. What we want to achieve with this event series is to take some of the framings and the problem statements in the consultation document, explore and scrutinize them to understand how they work towards delivering world-leading data protection standards that benefit people and help achieve societal goals. And the theme we're looking at today is around the current accountability framework, which is seen as a key driver of unnecessary burdens on organizations and a tick boxing exercise, not helping to protect people and to deliver societal benefit. So accountable and trustworthy AI is a theme throughout chapters 1 and 2 of the consultation, particularly the sections on automated decision-making and accountability framework. And our main question for today is, what does a meaningful and robust accountability framework for data and AI systems look like in practice? I'm very excited to have 5 brilliant speakers with us today who will bring rich perspectives and a vast amount of experience to this question. So we have David Erdos. David is the co-director of the Center for Intellectual Property and Information Law. We have Cosmina Dorobantu. Cosmina is Deputy Program Director for Public Policy and Policy Fellow at the Turing Institute. We have Divij Joshi. Divij is a PhD candidate at UCL Faculty of Laws and soon to be embarking on a very interesting project on law and the political economy of information systems. So do keep an eye out on his work. Jennifer Cobbe is a senior research associate at the Department of Computer Science and Technology at the University of Cambridge. And last but not least, we have Lillian Edwards. Lillian is a leading academic in the field of internet law. I'm sure you are all already very familiar with her. She teaches at the Newcastle University, and I'm also very happy to say that she recently joined Ada as an expert advisor on EU AI regulation. So I would like to turn to David in a few minutes, but first just to introduce some of the premises of the consultation around AI accountability. So the focus in chapter 2 of the consultation document is on reducing burdens to businesses, and it proposes to introduce a much more proactive and systemic approach with greater flexibility on compliance for the accountability framework, so that this will allow organizations to focus on the right outcomes to unlock the value of their data assets, and invest more efficiently in the governance and policies that protect personal data. So these are some of the quotes from the consultation document. And basically the aim is to develop a more agile regulatory approach that supports innovation and protects citizens. So my question to you, David, is how are the proposals marrying the two objectives of data protection regulation? On the one hand, enabling the free flow of data for economic growth, and on the other hand, protecting people and citizens. And maybe if you could also add your thoughts around what is the role of accountability in innovation, it'd be great to hear your initial remarks.
Thank you very much, Valentina, and it's great to be participating in this event. I mean, I actually have a lot of sympathy with the idea that the GDPR includes some overburdensome red tape, but I have very little sympathy for the notion that data protection isn't first and foremost about protecting individuals. It's personal data protection, protecting persons in data. And yes, of course, in order to get a well-balanced regime, and a regime which balances with other rights and interests, you do want to take into account the need for pro-innovation and pro-growth, but that shouldn't be the first and foremost. It's a byproduct of good regulation of personal data protection. I think it's really important that the regime remains focused on protecting persons in data. In terms of, I'll just say a few things about AI and accountability in the data protection framework. I mean, for me, it starts with being clear what personal data is at issue. I think that developers are often very good at doing that in terms of what's coming into the system, but they don't think through what data is being generated, which can even be from ordinary data to sensitive data, and the issues to do with intrusion, unfairness, and everything else that might flow from that. So the first thing is being clear on what data is at issue. Proactive transparency as well as reactive transparency can provide that. And you look at legal basis, including for sensitive data, and you know that is for good reason, actually quite strict and quite difficult. Now the government are proposing changing that for training and testing AI and for monitoring, detecting or correcting bias in AI systems, particularly the latter very audible aims. But again, you know, we have the research conditions about non-particularity, not focusing in on a particular data subject and treating them differently, and non-malfeasance, not causing substantial damage or substantial distress. And to the extent the government are proposing to move away from those, we need to look at other accountable safeguards. I mean, depending how anti-bias is drawn up, some data subjects might even consider it based on stereotyping, discrimination. It's possible. There are different ways of looking at bias. There needs to be the logic of the processing needs to be explicated for individuals, and they do need their rights to object. I mean, these would be very, very minimal safeguards, but we need to build in the accountability into any special regime. On Article 22, I just want to briefly close with a few thoughts about another form of accountability. Obviously, the headline is that there's the proposal to get rid of all the human in the loop, human intervention as regards significant decision-making, legal or similarly significant. I don't think it's a particularly well thought up phrase, but nevertheless, it is there because AI is the new cutting edge for data and persons. It's there because AI is very nascent in terms of its regulation. And it's there because the Data Protection Convention, updated, itself says that data subjects must have the right to their views being taken into consideration. And it's rather disturbing from the point of view of accountability under international law even, that the UK government while saying that ostensibly they've signed and they're preparing to ratify that convention and remain firmly committed to it, make no mention of the fact that simply abolishing Article 22 is hardly compatible with our obligations under this new instrument. So I will close there, and I'm really looking forward to the rest of the discussion and thoughts.
Thank you very much, David. This was really helpful. Cosmina, I'm going to turn to you next. The consultation says that the current rules may be generating a significant and disproportionate administrative burden, leading organizations to, quote, misdirect time and energy away from activities that ensure responsible use of personal data. So I was wondering what's your current assessment of the accountability framework, and how are accountability measures helping to achieve responsible data use in both the private and the public sector?
Sure. Thank you so much for having me and for such a great question. Let's take a step back a little bit and think about the broader picture, which is AI in general. And a growing literature proposes general principles to guide the responsible design, development, and deployment of AI systems. Among these principles, we have things like fairness, sustainability, safety, but we also have things like accountability and transparency. And accountability and transparency are what we call overarching AI ethics principles. They act as enablers for all the other principles. So the ability to address considerations related to fairness, to sustainability, to safety depends crucially on the existence of effective accountability mechanisms and the availability of information about an AI system. So whether we're talking about AI in general or data protection in particular, the principle of accountability plays a key role. Now, the million-dollar question in AI and data protection alike is, how do we move from principles to practice? And the current accountability framework proposes one answer to this question on the data protection side. It's not a perfect solution, but there are no perfect solutions. But in as far as it brings us closer to accountability in practice, it cannot be called a misdirection of time and energy away from the activities that ensure responsible use of data. Likewise, I don't think it will be a misdirection of time and energy to try and improve the current accountability framework. We can always do better, but I'm not convinced that the proposed reform offers substantial improvements. We're giving a lot of thought these days at the Turing to ethical assurance, a practical and holistic approach to the responsible design, development, and deployment of data-driven technologies. And our work has important lessons for those wanting to reform the accountability framework. When we're thinking about ethical assurance, and this comes from research led by David Leslie and Chris Burr at the Turing, we can organize the desirable properties of an assurance case into three categories. First, properties that support reflection and deliberation, that provide concrete means for the anticipation and preemption of potential risks and harms. Second, properties that support documentation and accountability. And third, properties that build trust and confidence through transparent communication. Now, these same properties would be crucial when thinking about the approaches that organizations must take to protect people's data. And by proposing a more flexible approach, the government runs the risk of lessening some of what we already have. So, for example, the proposal to remove the requirement for organizations to undertake a data protection impact assessment lessen the properties within the current system that support reflection and deliberation. Likewise, the proposal to remove record-keeping requirements under Article 30 lessens properties within the current system that support documentation and accountability. Now, reading the proposed reform of the current accountability framework, I do worry that we're looking at a reform that will result in a system that has fewer of the properties that we desire when it comes to ensuring responsible data use. So the reform comes at a cost. But as any economist would tell you, costs can be okay as long as they're offset by benefits. In this case, the government argues that the benefits relate to reducing the burden on organizations by giving them more options and flexibility. The key question, though, is who are the organizations that will benefit the most from this more flexible approach? If I'm an SME struggling to keep afloat in today's economic climate, which is a perfect storm with a pandemic, Brexit, and an energy crisis in the mix, will I be welcoming the government's proposal that I can now develop my own privacy management program? Now, what if I'm a large online platform with seemingly unlimited resources? Will I be excited by the possibility of developing my own privacy management program? I'm asking these rhetorical questions because in answering, are the costs of the proposed approach worth it? We must also answer who will accrue the benefits. And I'll leave it here for now. Thank you very much.
Thank you, Cosmina. Divij, following from Cosmina's intervention, we heard what would maybe not channel our efforts into a good direction. And I was wondering what would be your thoughts about the key ingredients for ensuring meaningful accountability. And if you have any reflections around this proactive and systemic approach that doesn't undermine the principle of accountability, but at the same time brings benefits for those involved both companies and citizens, as we heard from Cosmina. So it'd be great if you could share insights from your work, maybe also from the report that you were part of together with AI Now and the OGP on algorithmic accountability for the public sector, and any potential examples from an international comparison that you may have.
Sure. And thanks, that's not an easy question at all, but I'll try to answer it. And I think the first thing is to just understand that there isn't, one solution that's going to fit every context. And I think one of the results of that comparative review was that we wanted to understand, what are the fundamental enabling factors for accountability in different contexts, right? In the EU and in the UK, there have been kind of variations of Article 22 implemented in different jurisdictions, and different kinds of, you've had guidelines, you've had impact assessments and audits and several different departments and ministries looking into the same question. But at the end of the day, everybody's asking, has this been effective in ensuring accountability at all? And it's difficult to say because it's a fairly or a relatively nascent field. But along with what Cosmina already said, you need to have the key enabling factors in place and then build on top of that, which from my reading of this consultation report isn't what the government proposes to do. It says that accountability mechanisms are not so far working, and therefore we must remove them, or it says that accountability mechanisms are opposed to innovation in a way, which is a problematic framing, right? It's a very kind of techno-libertarian framing, which proposes that regulation is always contrary to innovation, and that's somewhat troublesome. But in terms of key ingredients, like I said, yes, transparency and participation, I think, are at the core of building anything that can eventually be meaningful towards public accountability, right? So mechanisms that are actually transparent about how data is being used within the context of data protection, of course, although this goes beyond data protection in many ways. How data is being used, how it's being processed, and all these principles are somewhat already part of the data protection framework, right? Within the fairness principle or within different mechanisms for transparency, like data protection impact assessments. And participation is another key enabler in that people should know what's happening, both in terms of regulatory proposals, but also in terms of how you're trying to build accountability frameworks that are eventually meaningful. For example, when you're trying to build an impact assessment, a common kind of accountability mechanism that's in place now, which is algorithmic impact assessments, but the impacts are solely seen from an organizational perspective, where, say, the technology company, let's take an example of a big social media network that conducts human rights impact assessments, but doesn't adequately consult affected populations on the ground who are affected by the use of their technology, and it only considers its own organizational perspective of what human rights are. That's never going to be effective because there's a disjunction between what people on the ground are actually, how they're assuming impacts to be and how they're feeling the impacts of a particular technology and what the organization assumes those impacts to be. So this disjunction needs to change, and there needs to be kind of meaningful participation built into accountability mechanisms. So those are two kinds of external enabling factors, but internally we also notice that there simply hasn't been enough regulatory capacity, political will, or institutional incentives built into accountability frameworks that are already implemented around the world, including in the UK. So even though, for example, you might have procedural requirements such as Article 22 in the face of automated decision making, because of both because of kind of the lack of clarity around the framing of these legal obligations, but also because of the lack of enforcement of them, it's difficult to say that there's actually any accountability resulting from this. This doesn't mean that procedural mechanisms are necessarily wrong or that they're not helpful. It simply means that there hasn't been the capacity or the will or the incentives to enforce these important mechanisms for accountability. So I would say my final proposal or my hot take would be to take a step back and see why the things that they propose aren't working, why aren't they working? And is it simply that accountability is a barrier, or that you haven't implemented accountability effectively enough?
Thank you, Divij. These are great points. Thank you for highlighting those. And Lillian, going now to you, I was wondering whether you'd like to complement any of the thoughts you heard from the previous speakers, and to invite any reflections on what types of rights, safeguards, controls do we need to put in place for protecting people in this context of the pro-growth, pro-innovation regime, and how do we achieve high standards for data protection? And are the proposals moving us in this direction?
Sure, thank you. How long have you got? So my usual joke at this point is now every time I hear the word pro-innovation, a kitten dies, but I know that's not an entirely constructive way to start. So I spent this morning looking at pieces of paper, and indeed I think in terms of, unreasonable burdens on industry, someone might think about the unreasonable burdens of replying to consultations right now, because here I am in a sea of pieces of paper. But one of the interesting parts is to look at the aims of the accountability principle as transcribed into the DCMS consultation on para 143, which are protection of data rights, transparency, public trust, embedding of data protection into organizational practices, regulatory clarity, confidence and compliance, and aiding of enforcement. And against that we have, which all sound like a pretty good list of objectives to me, we have this assertion that the rules we currently have are disproportionately burdensome. And I'm very glad this is a consultation, because it seems to me that that is so far an allegation, an assertion that in many, many cases within the consultation does not seem to be based on empirical evidence. We see repeatedly, we have heard that, it seems that there is a possibility that people are unclear about. If your main problem is inclarity, then the answer should be guidance, better guidance, or indeed asking people to read the guidance that is already there. Read the syllabus. And that is the phrase that comes up again and again and again. And I would direct people towards, the really excellent guidance that is already out there, notably in this country from the Information Commissioner, but also from Turing, from CD, from the Council of Europe, from the European Data Protection Board, from the EDPS, the list goes on, maybe there's an argument for, a canonical list of guidance, but, maybe that's what legislation is. But that's one point I would like to make to start with, is that we should think about clarification as an instruction to guidance and reading what is already there, rather than, as Cosmina put it very well, to, creating, I think, new legislation which may take away the benefits that we're trying to enhance. In terms of other points that I wanted to make, I have now lost my piece of paper in the midst of all these pieces of paper. Well, let me address the elephant in the room, which I'm sure is why I'm generally being asked to be on panels, which is Article 22. So my view has been throughout that Article 22 appears to be set up as the sacrificial lamb in this consultation. And I'm not really that opposed to that, because the truth is right now, Article 22 has almost zero effect in either vindicating individual rights or creating accountability, because, as David said, it is an extremely ill-drafted, very old provision from the beginning of time, which was, you know, the 80s, the mid-90s, right? Because it's basically based on something that was in the DPD 1995. It is not, and I always use the old Yorkshire joke, if I was trying to achieve accountability and individual control over automated data processing, it is not where I would start. Having said that, I think to throw it out in the bin is unfortunate. You know, and I've just been sitting here and making myself a little list of places where Article 22 could be useful if it was better phrased. So, for example, one place where it has actually been used is the Dutch Uber cases. So there we're talking about the least empowered, least well-paid, often racially discriminated against workers, right? Who are saying, we are being sacked, we are being fined, we are being disciplined by our much more empowered and to a very large extent invisible software automated overlords. And our only recourse, more or less, are two things, which are subject access requests to try and find out what data is being collected about us and how it is being used, right? Which is surprisingly another part that is under attack in this consultation. And the right to object to solely automated processing. And it's hard to imagine a world in which we don't think it is a good idea for people to be able to object to truly solely automated processing that has these Kafkaesque, abusive, and opaque effects, right? And to go to, you know, my other list of places where this is useful, face recognition cameras, as in Bridges Against Southwest Police, right? Do we actually think it's a good idea that these kind of systems should be able to decide that somebody is a likely terrorist or should be stopped and searched or should be excluded from a public area on the basis of a solely automated process without having any recourse against it? I don't think many people would say that was an accountable system. You know, to go to the really basic ones, you know, the original systems that say you can't have a loan, we're not going to tell you why, go away, we're not going to reveal our training set, we're not going to say whether you were in discriminated against group or simply if there was a bad error in the transcription of the underlying data. Benefits, you know, the fact that you're not able to receive a certain benefit, is that something that should not have a right for you to seek clarity? We had the off-call algorithm last year. Was it last year now, or was it the year before? You lose track in the pandemic. You know, so that was a classic case, it appeared to be, of an automated decision that was making decisions about whether you got to go to the university you wanted to, or whether you were being unduly penalized because of the school you went to and not because of your own achievements, right? We never got to find out if that was an Article 22 decision because the government caved. However, there was a really worrying development within that, which is as to what is a solely automated decision if the human just provides the input data at the start, you know, and that is going to be all decisions because computers do not yet have the ability to go out on their arms and legs and collect all the data about them world themselves. So I'm very, very much, I could go on like that for a long time, but I'll stop. I wasn't even getting to triage and CVs. I am strongly in favor of rethinking Article 22. I am not in any way wedded to it. We need to investigate what types of decisions we call solely automated, which ones we call assisted, which ones we need to have which remedies as against, which ones make these significant or, you know, legal effects. It needs a wholehearted review, absolutely. Why are we arguing over whether to keep a provision that is now 30 years out of date, 35 years out of date? And one place I would say we should look there, and we should have a select committee discussion about this or something of that kind, because it is not something you can do overnight in 3 pages of a consultation. One place we should be looking towards, and again, I know this is probably not something we're really meant to be saying right now, but we should be looking towards the draft EU artificial intelligence regulation, which is new and not 35 years old. And there we find a much more sophisticated set of proposals about what human oversight might really mean. which is not just this on-off A22 objection concept. It is putting the impetus on the builders of the systems as opposed to the deployers of the systems, who may indeed sometimes be unduly burdened, right? But it's putting the emphasis on the builders of the systems to build systems which are capable of human oversight, right? Are these systems that are transparent enough that you can combat automation bias, right? Computer says no. Are they transparent enough that you can see when the machine might be making a mistake, when you can see that it's going off the rails? That is fundamentally, in rather more detail than I am anecdotally putting it, what printed out, Article 13 of the proposed AI reg tries to do. Now, I'm probably well over my time, so I will just mention that I think actually, in many ways, having made this case about improving, not getting rid of A22, the three parts for accountability that worry me most within the consultation are, as was already mentioned, I forget, sorry by who, probably several people, data protection impact assessments, which seem to me to be utterly the heartland of what is meant to be an increasingly risk-based system. The consultation claims correctly that we should not have a one-size-fits-all system. We should have a risk-based system. Well, if you want to have a risk-based system, you have to assess what your risks are. That is the nature of a DPIA. It seems very hard to get away from that one. I'd also just mention as an absolute personal point of grief that I was looking at this morning, the suggestion that we should get rid of data protection officers, because they are this burden on small enterprises who have to appoint one person who sits independently within the company and does nothing else. That is not what the GDPR says. The GDPR says that the data protection officer function, and it is a function, not a person, can be delivered by means of a service. So you can, and I know law firms that do this, sign on to a law firm or a company that will deliver DPO as a service. And that does not have to be one person. It does not have to be a burden on your company. So I just want to sort of correct that as a piece of factual information. And the last thing I would say is subject access requests. I don't know if that's really in the remit of this discussion, but again, it seems to me that you cannot have a database society of any degree of fairness, accountability, and transparency without giving people the fundamental right to know what data is being collected about them and what is being done with it, and particularly to impose charges is again to act against those who are least empowered, most socioeconomically deprived, most ignorant, right? And that is perhaps the single provision in the consultation that I feel needs a bit more work. And I'll stop there.
Thanks, Lillian. And not to mention the importance of subject access requests in for research purposes and to reveal all sorts of potential infringements on data protection and privacy. I'm going to open up the floor for more specific questions around some of the specific provisions that Lillian also mentioned around DPO, different approaches for data protection impact assessments, removing prior consultation with the ICO, and all those more flexible measures in the consultation. But and also I'd be super glad to receive your questions in the Q&A or in the chat. And in the meantime, Jennifer, to add any remarks or thoughts around what types of transparency should be in place for demonstrating accountability, and what are her remarks around what would a robust accountability framework should look like.
Thanks, Valentina. I have 3 points. The first of which is about where we need to put our focus when talking about accountability and algorithmic systems. The second is about the role of data protection law in that. And the third is kind of a more general point about the idea that accountability might in some way be a barrier to innovation. So I think, first of all, we need to be clear about what we actually mean by things like accountability of algorithmic systems or algorithmic transparency or anything like that. I think what we want to prioritize isn't to make algorithms themselves transparent or accountable. That was kind of a bit of a diversion that a lot of research and a lot of policy work went into a few years ago. But thankfully, things were beginning to move in the direction that I think we need to be looking instead, which is that we need to make the people and organisations responsible for those algorithmic systems accountable for their commissioning and their design and their deployment and their use. This kind of information would help with properly scrutinising algorithmic systems before they're deployed and used, so that regulators or other oversight bodies can identify problems before they go live. And it would also help spot developing problems once they've been deployed, to try to minimise any harm that might be caused, once they're sort of out there in the wild doing what they do. So this kind of holistic accountability right across the whole sort of algorithmic sort of piece is about making that entire algorithmic process reviewable, from the first decision to use an algorithmic system right through to the actual deployment and use of that system in practice. And this should be, I think, ongoing. Real accountability isn't an event or a one-off. It's not just an objection. It's a process. It's a dialogue between the people who are developing systems, the people who are affected by systems, the people who are overseeing systems. It needs to be really an ongoing thing. I think secondly, and following from the above, and sort of kind of agreeing with what Lillian was saying, and David, I think as well, is that what is in GDPR at the minute is wholly inadequate. Neither Article 22 nor really the rest of GDPR offers a route to the kind of organisational accountability for many of these aspects of algorithmic systems that I think we need. So I wouldn't be totally opposed to reform of data protection law on this point. So I do think that the government's proposals don't do in any way what I have in mind, and I think they're seriously misguided, and I would echo much what David said about this as well. But I would also question the extent to which we should be really relying on data protection law for this kind of thing at all. Like, don't get me wrong, I'm a big fan of data protection law. I think it's fundamentally important in the modern world, and in many ways should be strengthened, not weakened. But I'm not convinced that we should try to stretch data protection law to deal with sort of all technological problems. I don't think people have talked about data protection law being the law of everything. I think that's not necessarily very helpful. I think data protection law should provide a solid basis of sort of widely applicable general protections for people in circumstances where their personal data is being processed. And on top of that, we should probably have a range of more focused laws and regulations that address certain specific things, or maybe provide a more particularized legal regime for certain sectors or for certain processing activities, or however else you want to frame it. So I think that's something that's worth considering in more depth, and my own research is also heading in that direction. And then there's the kind of third, only sort of semi-related point, which is I think we need to be much more critical of the concept of innovation and be much more open to the idea that sometimes sort of so-called barriers to innovation aren't actually necessarily a bad thing at all. I often say that we need to recognise that not all new ideas are good ideas, which is obviously a very simplistic way of putting it, of course, but part of the purpose of law and regulation is to try to protect people against harms or mitigate things that might potentially be harmful, or which bring negative consequences, or which are otherwise undesirable for some sort of public policy reason. And as David said, really the point of data protection law is to protect people around the processing of their personal data. So just because something is new or innovative doesn't mean that the law shouldn't play that role in making sure that we have some kind of oversight of what's going on with it. So I would argue that that's a beneficial and desirable thing. So those are the 3 points that I wanted to make, and I'm looking forward to the discussion. Thank you.
Thank you very much, Jennifer. Now I'm going to invite all of you to have another round of brief remarks on maybe some of the more specific proposals, if they're comfortable doing that in the consultation. So you already heard Lillian mentioning the provision on removing the DPO or changing its nature under this more flexible privacy management framework. There's also this provision on removing prior consultation with your ICO before high-risk processing. There are also new proposals around more flexible record keeping and organizations having to provide remedy action plans to the ICO in case they infringe rights. So and also this shift from reporting data security breaches that might result in risks to the rights and freedoms of natural persons, to only be possible to only be done if there was a material risk. So and I just like to highlight that even if these proposals do not go forward, the government still intends to remove the requirements on public authorities to appoint a data protection officer and to limit record keeping. And I was wondering, how do all of these proposals square with this more flexible how do these proposals under the privacy management framework square with the more permissive and facilitating data access and data use provisions from Chapter 1, especially around AI and machine learning, and to hear your views whether there are also potentially good proposals that we should be encouraging going forward. There are, for example, the proposals on introducing transparency registers, but at the same time keeping in mind that the intention is to limit record keeping for organizations processing personal data. So if you could have some brief remarks on this. And also I saw a question for Lillian in the chat. And Lillian, when it's your turn, maybe you can also address this question on how do you see the relation between DPIA and algorithmic impact assessment if we are looking to the EU AI regulation as a model going forward? So maybe David, if you'd like to come in first.
Oh, and thanks again, Valentina. I mean, I don't wish to break this wonderful consensus that we have building here needlessly, and I do very much appreciate all the incredible and interesting thoughts that have been presented. But to give some of the kind of more jaundiced understanding of the GDPR a bit more of a fair wind, I do think that you know, we talk a lot about it being risk-based, but actually when you go through the various provisions, often the way it ended up being drafted meant that a literalistic approach, at least, or even any, you know, means that you're left with precious little ability to do risk-based. So, you know, you don't have to do record keeping if you don't have more than 200 employees, but all of a sudden you do if the processing is not occasional, and you do even if it is occasional, if it involves any special categories of data, which, I mean, health data, any organization of any size is going to have some kind of I'm off sick today type, you know. So that didn't really end up very risk-based. I don't think that the Information Commissioner here did itself any favors when it came up with a very opaque and difficult to interpret list when you allegedly have to do a DPIA, including comparing or matching personal data from different sources. I mean, that could be interpreted incredibly broadly, simply comparing two bits of data from different sources. I don't think that's really what they intended, but nevertheless, it's very opaque and could be expansively interpreted. So and DPOs, of course, with, okay, I think they did something for the parish councils, but nevertheless, you know, very low risk public authorities, very small ones, having to appoint DPOs. So I'm not opposed to revisiting some of that. I think that DPIAs should be retained, but they should be focused on truly high risk processing. I think that DPOs do have a role, but I wouldn't be opposed to making the public and private sector more equal in that. I think record keeping is better integrated into privacy notices where possible, and granularized. And I don't see much of a case for, in and of itself, low risk processing being dealt with in different ways. But it goes back to the really, really valued point which was made about the lack of enforcement. I mean, when you have very low levels of compliance and very low levels of it being seen as a priority, and you have 30,000 complaints coming to you, and you're processing in some sense, but you've only managed to deliver 3 enforcement actions through fines. You know, this is a tiny, tiny number. I don't know how you don't end up in a situation where the law isn't worth the paper it's no longer written on. It's simply there, and in a way you can get more and more dysfunctionality because more and more of the law, you know, let's take the issue about someone having a Facebook like button or other forms of interaction with Facebook becoming a joint controller. I mean, how many organizations have actually acted on that and actually thought through the implications or indeed been held to account for it? I would have thought in this country almost zero. So we really do need a more effective law, and I would be in favor of a law which was more balanced, if you like, was more genuinely risk-based, but then had proper accountability mechanisms to allow data subjects to claim their rights, because I think to some extent we're engaged in privacy theatre here, which has been in the literature a bit, where, you know, we bandy around all of these protections, but they don't mean anything because companies know very well that the likelihood of them being enforced is very, very, very slim.
Thank you, David. Cosmina, would you like to take around 1 minute to share your thoughts?
Sure. I mean, to pick up where David left off, my fear is that, you know, enforcement is going to be even less with the current proposal than it has been. And you know, when you think about the ICO, it definitely does not have the resources to match the resources of the companies that they're supposed to be regulating. And this has been obvious as they were trying to battle some of the tech giants. And although they've done a tremendous job at basically doubling in size, I think they have about 800 people right now, they're still nowhere near having the access to the legal resources to fight these companies, or have enough people power to actually look at what's happening. In a way, a more flexible approach is going to make the burden even greater on them, because you have to figure out what each company is doing to try to meet their legal obligations. So it's making their job even harder than it has been. Now, one of my fears is that, you know, when you think about governance structures, they usually tend to kick in a little too late. You know, we look at, you know, how, you know, we build things and then we look at how they work, as opposed to sort of do the anticipatory work. And I'm afraid that the current proposal is sort of encouraging us to do more of that and to sort of put less thought into, you know, what would happen and what the impacts are at the very, very, very beginning of a project or of an idea. And, you know, if you read the ICO's response, which I think is pretty good when it comes to data protection impact assessment, or you know, when they talk about the government's proposal to remove the requirement for prior consultation with the ICO when an organization has identified a high risk that cannot be mitigated. So I think, you know, we need to give more thought as to how we can sort of prevent things from happening rather than fix things once they've already happened. And I definitely, you know, I want to sort of, you know, give a thumbs up to Jennifer's point about innovation. Not all innovation is equal, and we shouldn't want all innovation. When I'm reading recent articles about, you know, the schools that are using facial recognition technologies so that kids can pay for their lunches, or the pictures you've seen just in the past weeks of, you know, dogs with, you know, robot dogs with guns on them or whatever. I mean, you know, I dare to question the societal value of those innovations. So I'll leave it there. Thanks a lot.
Thank you, Cosmina, and thank you for bringing forward the points on the ICO. I think it's quite striking throughout the document that you see a lot more actually burden on the ICO to bring forward to be able to assess all these flexible approaches to impact assessment and to how accountability should be done. And also on the point on innovation, I just wanted to mention that last week we had an event on what does responsible innovation mean, who does it and who is it for. So if you're keen to listen back to some of those questions, the recording is available on our website. And Divij, I want to turn to you if you have any final remarks or points that you would like to complement from the other speakers.
Sure. I actually wanted to just take off a little bit from what Jennifer was talking about in terms of when we're talking about responsible AI or regulating artificial intelligence, it's a bit vague. We don't really, what is AI? What are we trying to regulate? What are we getting at? And that question first needs to be answered. And then we need to move on to the second question of where does this regulation need to be housed, right? To what extent does data protection and particularly personal data protection converge with what we see as the harms of artificial intelligence, automated decision-making, algorithmic decision-making, and so on. And there's not a total convergence here, right? So other countries around the world, for example, have created de novo regulations which focus only on automated decision-making. See Canada's proposal, for example, or Canada's regulation. But over here, the tricky bit is that, in the EU, you've had as Lillian mentioned, kind of data protection regimes going back to 1995, which had some kind of vague framework around automated decision-making. It got transposed into the GDPR, got transposed into national domestic legislation around the EU. And now it seems to be, no one really seems to know what should you do? Like, what should the data protection regulator really be responsible for? Because procedural protections for automated decision-making are a bit anomalous and don't neatly fit into personal data protection regimes. And as such, these are kind of almost specific to the EU GDPR. They're not always present in other regulatory regimes around AI, proposals or regimes around automated decision-making. But it is interesting because there is definitely some role that data protection regulators can play, and you can evolve this into making these more efficient. There have been proposals, for example, about how DPIAs can kind of be transposed into algorithmic impact assessment. I think Margot Kaminsky has done some interesting work around how this can be done. But there's also difficulties in terms of what happens when it's not individual data that's processed, but there's discriminatory effects that are felt on groups based on group level processing of data. And this happens regularly in kind of policy making and the effects that don't necessarily involve the processing of personal data. So GDPR won't cover that at all, presumably, right? And also similarly, for example, are data protection regulators well equipped to understand discrimination law? Or can a DPO in an organization really should they really be tasked with understanding the biased and discriminatory effects of potential AI processing of any kinds of data? So these are kind of fundamental conceptual questions that I think really need to be figured out. And it makes sense to think about this at the outset instead of continuing forward with having more obligations under data protection law. And then realizing that, oh, we now need like a whole new AI regulation to deal with this instead. So thank you.
Thank you, Divij. Lillian, could you briefly address the question in the chat as we're approaching time, and then I'll also pass it to Jennifer for a couple of final remarks.
I was just going to say actually that I bet Jennifer can answer that much better than me, because the EU AI reg doesn't really actually require an algorithmic impact assessment. It has a setup very briefly whereby certain systems are deemed to be high risk. And then if they are high risk, then you have to self-certify, which you could take as an algorithmic impact assessment, that you have met certain essential criteria, which include the one I was talking about human oversight. But it's kind of an orthogonal rather than parallel or similar development. So I'll just leave that there and pass that over to Jennifer. But I thought Divij made some really interesting points there that I'd actually quite like to pick up on, and also Cosmina. So one point about innovation, and I really, really applaud, huge hand claps to Jennifer raising that, is that sometimes I feel that we have only one framework for looking at innovation, which is who can we sell or transfer our data to so that they will invest in creating innovation that will benefit the UK. Now, we don't like that, right? We don't like the products of AI innovation, but there is more than one way to skin a fish, or whatever the phrase is. So, for example, we find again and again in public engagement that the public, and it is the public benefit we're in the end talking about, are really unkeen on their sensitive health data being transferred to private companies, whether for research or innovation or however it is framed. An alternative way to look at it, pardon me, I haven't got COVID, is to suggest more investment into our public bodies like the NHS for them to make use of our data to create innovation and social benefit. And that way we also lose the uncertainty of the further processing and the dissemination of that data to means which we can't control. And we get the benefit of the long-term profits, as well as the innovation and the control. So it seems to me to be win-win. So sometimes I feel that what we need is a wider consideration of economic models of innovation and investment. Okay, that's one point. On enforcement, which I also thought was a brilliant point, and I was laughing away at David, because although I totally agreed with what you were saying, I wasn't quite sure what the end point was you were reaching, which is like, you know, is it better to have a system where you half think that you can get away with ignoring good data practices to one where you know that you can get away with ignoring good data practices? Is that the end game? I think hopefully that is not the end game. And I just want to suggest two other frameworks, as it were, for enforcement that we could talk about more beyond the obvious point that more resources are needed for equality of arms. So one is multi-regulator cooperation, because I absolutely agree that the ICO cannot be the regulator of everything, because we live in a world made of data. It does not, for example, have the internal expertise to decide about all fundamental rights, about equality, about freedom of expression. We already do have an extremely successful model in the UK on a no statutory basis whatsoever right now of multi-regulator cooperation between, for example, the ICO, the CMA, the FCA, and so forth and so on. And I would very much like to see that expanded and even put on some statutory basis. And another point that I've been flinging around myself is, should we be thinking about an ombudsman for AI? Should we be thinking about a body that responds to individual complaints in a world where people mostly don't understand how their data is being used, or how AI works, or who the data controllers are, as David also pointed out? That would serve various purposes. I could see this person referring complaints to the right regulator. I could see them keeping overall charts of patterns of complaints, right? So that we have transparency reports, not from providers, but from the public sector. And I could see them, say, organizing class actions or, you know, representative actions, which at the moment is left to the entirely underfunded NGO and civil society sector. So it's just, you know, let's think out the box a bit. I am all in favor, in fact, of reform with the GDPR. I would just like it to be, you know, thoughtful reform. Okay, sorry, I'll stop.
Thank you, Lillian. Jennifer, with the risk of running 1 minute over time, would you like to say a few last couple of words, and I'll wrap up.
Yes, thank you, Valentina. Just very quickly on Lillian's point there about the ombudsman. I wrote a piece for the admin law blog, I think last year, that kind of called for an ombudsman for public, or the parliamentary ombudsman to kind of be put in charge of overseeing public sector automated decision making and taking up complaints and investigating and taking whatever action we needed, much along the same lines as you're talking about, Lillian. I would agree that actually that's not necessarily a bad idea either for the private sector. So maybe that's something that's really worth looking into. I think one of my major criticisms of data protection law as it stands now is that its oversight and accountability regime is still too dependent on a sort of ideal of this active, engaged data subject, sort of keeping an eye on what's happening and exercising their rights in a very neoliberal way and lodging complaints to supervisory authorities. And that's one of the law's major weaknesses as I see it. So I think that getting rid of things like DPIAs or DPIOs are really seriously misguided. The law should be moving away from burdening data subjects and reducing the law's reliance on data subjects. But a lot of those proposals seem to go in the exact opposite direction, removing the other mechanisms for accountability and oversight and leaving it up to data subjects. While of course also charging for subject access requests, which would then dissuade people from actually engaging with their rights and doing those things. But the enforcement point that others have mentioned is a real serious problem. For most things, I think, as of today, data protection law just is not worth the paper it's written on. It may as well not exist. If you repealed GDPR yesterday, nothing would have changed today, I don't think, because nobody's scared of getting any enforcement action. I'm not sure, though, that looking for more mechanisms for accountability to data subjects, as David suggested, would really help sort out that enforcement problem. If data subjects' choices aren't backed up by a regulator and a sort of broader regulatory regime that takes these things seriously and actually acts on complaints, then what is the point of giving data subjects more control or better mechanisms for accountability to them? They'll just be completely ignored as they are today. So I think that would be a limited solution, but I'm not opposed to giving data subjects more accountability or whatever else, but that has to be backed by an actually effective regulator who will step in and make sure that they're complied with.
Thank you so much, Jennifer. I think that's a great way to round off our discussions. And I'd like to really thank all our panelists so much for taking the time to join us this late lunchtime, and hugely appreciate all your comments. It was great to have you all here and to hear all your different perspectives and the different angles around the consultation. We really appreciate it, and thank you to everybody for joining us and staying until the end. As I mentioned, we'll do an event summary and post it on our website. If anybody wants to draw on the interventions we heard here from our speakers. Just lastly to say, we have two more events coming up. The next one is scheduled for next Wednesday, the 27th of October, at the same time at 2 p.m. And we're going to focus on the concept of fairness and what should fairness obligations look like, which is an open question in the consultation, and the government is seeking views. Without keeping you any longer, if you're interested to register for that event, please do join us again next week. And thank you so much, everybody, for your time and for the discussion today. See you soon.
Thank you.
Bye.